So I'll start with the topic of the real and present danger of climate change. In May 2016, the level of carbon dioxide measured at Cape Grim on Tasmania's northwest coast, aptly named, exceeded 400 parts per million for the first time. Cape Grim is one of only 3 World Meteorological Organization global superstations for the measurement of greenhouse gases. Now, this trend has continued. Carbon dioxide levels in August this year averaged 401.42 parts per million. That 400 parts per million threshold was first recorded to have been exceeded at another of the WMO global superstations at the Mauna Loa Observatory in Hawaii in 2013. When that occurred, NASA climatologist Dr. Gavin Schmidt observed that we are a society that has inadvertently chosen the double black diamond run without having to learned to ski first. It will be a bumpy ride. Now, as a keen skier, I like choosing the double black diamond runs, but with no snow, it's not so much fun. This year at Mauna Loa Observatory, the mean weekly concentrations of carbon dioxide as of 23rd of October 2016, only a month ago, was 402.27 parts per million. And the May 2016 value was 407.7 parts per million, which was the highest monthly value ever recorded. So these measurements at 2 of the 3 stations this year make it almost certain that the global annual average carbon dioxide level will exceed 400 parts per million for 2016. Now, this is, just to put into some perspective, a 44% increase from the concentration of 278 parts per million around the year 1750. I know it seems a while ago, but it's come up a lot. And likely it's going to be the highest level that we have had in the past 2 million years. Now, this large and rapid increase in the atmospheric concentration of carbon dioxide and other greenhouse gases since 1750 is having significant consequences for the planet. As was mentioned a moment ago, 2015 was the warmest year on record for the globe since reliable global surface air temperature records began in 1880. But the last 15 years are among the 16 warmest years on record. But more is to come. 2016 is very likely to be the world's hottest year on record. The global temperatures for January to September this year have been 0.88 degrees Celsius above the average for the 1961 to the 1990 reference period, and approximately 1.2 degrees Celsius above the temperatures of the pre-industrial period. It's a little unevenly distributed, but just give me some idea. More than 90% of the northern hemisphere land areas north of the tropics were at least 1 degree Celsius above average. Parts of Arctic Russia were 6 to 7 degrees above the average, while other Arctic and subarctic regions in Russia, Alaska, and northwest Canada were at least 3 degrees Celsius above the average. In the southern hemisphere, many areas were 1 degree or more above average, including northern South America, northern and eastern Australia, and much of southern Africa. Now, this warming is significantly affecting the oceans. The globally averaged ocean temperature and heat content are increasing, and the warming extends to at least 2,000 metres, 2 kilometres below the surface. Temperatures were above average over most ocean areas and were 1 degree Celsius or more above average in many parts of the tropical East and Central Pacific, the Eastern Tropical Indian Ocean and the Indonesian archipelago, the Tasman Sea, the West Subtropical North Atlantic, and the Far North Pacific. Now, the very warm ocean temperatures contributed to significant coral bleaching in some tropical waters. One of the most significantly affected areas was the Great Barrier Reef, where record high temperatures occurred in March 2016. Coral mortality of up to 50% was reported in the northern parts of the Great Barrier Reef north of Lizard Island. Globally, the average sea level has risen over 20 centimetres since the late 19th century. Get your ruler out, think about 2/3 of your ruler, it's gone up. And about 1/3 of this rise is due to ocean warming and the rest from melting land ice and changes in the amount of water stored on the land. But global sea levels rose very strongly during this 2015 to 2016 El Nino event, rising about 15 millimetres between November 2014 and February 2015, which is well above the post-1993 trend of 3 to 3.5 millimetres per year. And the early 2016 values reached new record highs. So coming to Australia, the consequences of the increase in the atmospheric concentration of carbon dioxide and the other greenhouse gases include at least the following. First, the mean surface air temperature and the surrounding sea surface temperature have increased by about 1 degree since 1910. The duration, frequency and intensity of extreme heat events have increased across large parts of Australia. There has been an increase in fire weather and a longer fire season across large parts of Australia since the 1970s. Rainfall patterns have changed significantly, including, first, a reduction in the May to July rainfall by around 19% since 1970 in the southwest of Australia, a decline in the April to October growing season rainfall by around 11% since the mid-1970s in southeast Australia, and conversely, an increase in rainfall since the 1970s in northern Australia. Comparatively, however, Australia is less at risk from climate change than other countries in Asia and Africa. The Global Climate Risk Index 2017 measures the level of exposure and vulnerability of countries to extreme events. The 10 countries most affected by extreme weather events include 6 in the Asian region, being Myanmar, the Philippines, Bangladesh, Pakistan, Vietnam and Thailand. Now, poor countries in general are more exposed to climate change-boosted extreme events. There is unfairness in the distribution of these events. The least developed countries have contributed only a small fraction of the greenhouse gases warming the planet, yet they suffer much more from extreme weather that has been made more intense and frequent due to the greenhouse gases emitted by developed countries. So when we look at climate change, we can term it a wicked problem. Indeed, some term it as a super wicked problem. So what's a wicked problem? Well, wicked problems involve a combination of high levels of complexity, uncertainty, and value divergence. Climate change exhibits all of these features. It involves polycentricity, that is, a series of linked problems, none of which can be resolved in isolation. There are interdependencies in the environmental systems and between the causes and consequences of climate change. There are uncertainties in the knowledge base, including the extent of climate change and the causes and consequences of climate change. There is uncertainty in relation to the risks and consequences of both action and inaction. There is divergence in views as to the need for and the extent of change in law, governance, and behaviour to address climate change and its consequences. and the allocation of responsibility for any such change. There's divergence in views about values and equity issues, including the equitable sharing of burdens and benefits. There's divergence in views as to the choice of solutions to climate change. These and other issues of complexity, uncertainty and divergence combine to make climate change a wicked problem. Now, solving wicked problems, as the name might suggest, is inherently difficult. Three commonly recommended approaches are better knowledge, better consultation, and better use of third-party partners. There is a need to improve significantly the knowledge of both the wicked problem of climate change, its causes and consequences, and its possible solutions. Better consultation and collaboration with stakeholders is necessary to develop effective, efficient, and equitable solutions to climate change and its consequences. Such collaboration may involve reliance on non-governmental stakeholders, including the private sector and community organisations. The challenge posed by climate change is to develop new thinking about the multiple causes of problems, opening up new insights about the multiple pathways and levels required for better solutions, and gaining broad stakeholder acceptance of shared strategies and processes. Now, this special thematic issue of the University of New South Wales Law Journal on rethinking climate change and the law addresses this challenge. The various articles that you have to read examine from diverse perspectives the problem of climate change and the adequacy of the law in solving it. The diversity of perspectives represented in the articles is illustrative of the complexity and multifaceted nature of the problem and the solutions to it. An overview of this diversity of coverage can be provided by grouping the discussion into two categories: the problem and the solution. So the first is understanding the nature of the problem of climate change. Now, climate change is a problem that crosses boundaries of knowledge disciplines. It's a scientific, economic, social, environmental, and legal problem, to name but a few of the knowledge disciplines. It is also a normative problem, involving conflicts in values and what is equitable. Understanding this transdisciplinary and interdisciplinary nature of the problem is important if effective, efficient, and equitable solutions are to be found. Too narrow a conception of the problem confines the solutions. For instance, characterising climate change as simply a scientific problem leads to devising scientific solutions alone. These scientific solutions will neither be effective nor efficient in addressing the multiple causes of the problem, nor will they be accepted by all stakeholders as equitable. Climate change is clearly a problem of the past. The climate change-induced events suffered today are a product of past behaviour. But climate change is also a problem of the future. Climate change does not readily fall within any pre-existing category of harm that's recognised by law. The future harm will be dispersed across the globe, affecting all people, but some people with particular severity. Although there's a reasonable certainty that there will be future harm, the precise nature, extent, and incidence of the future harm is uncertain. There's an urgent need to examine how well the law, in all its areas, is equipped to respond to this certain future harm, but uncertain incidence and extent of harm. Climate change poses other challenges for the law. It's a product of multiple actors, some making large contributions, the so-called major emitters, but most making small contributions to climate change. how is responsibility for past and future harm to be allocated? Climate change is also a product of slow onset processes rather than discrete actions or events causing acute symptoms. Climate change is the sum of innumerable small actions, each seemingly insignificant, but collectively and cumulatively significantly contributing to climate change. These and other diverse facets of the climate change problem need to be better understood. So let's turn now to finding the solutions to the climate change. Albert Einstein is often attributed, but indeed might have been misattributed, with saying that the definition of insanity is doing the same thing over and over again, but expecting different results. Well, nation states' past responses, or in some cases lack of responses, to climate change involve an element of insanity. The same things have been and continue to be done, but expecting different results. Instead, there's an urgent need to do different things. For the law, this involves thinking creatively and laterally across different areas of law and different jurisdictions. Now, law is a form of social ordering, and it creates forms of organisation. There's a need to better understand these forms of ordering and organisation, to question assumptions as to the law and its role and application, and to devise creative and innovative solutions and reforms. One type of reform is to evolve from top-down to bottom-up solutions. Now, this type of reform is being evidenced in three ways. First, in international action to address climate change, the Paris Agreement under the UN Framework Convention on Climate Change has moved from top-down imposed targets to mitigate greenhouse gas emissions to bottom-up nationally determined contributions. Warinki Singh and Dubler and McAdam discuss this bottom-up approach of the Paris Agreement in their articles. Second, there is an increasing recognition of the need for bottom-up action by communities to complement the top-down action by government. This is facilitated by giving respect and recognition to individuals, groups and communities, thereby promoting environmental justice. Lack of recognition inflicts damage. It constrains individuals, groups and communities, and it leads to ineffective participation in the polity, that is procedural injustice, and to inequalities in distribution of environmental benefits and burdens, distributive injustice. Giving respect and recognition to individuals, groups and communities encourages a plurality of viewpoints and values, which is necessary for developing solutions to the wicked problem of climate change. Participation in the polity should not be screened so as to allow only those people or those viewpoints and values which are predetermined to be acceptable or which fit within preconceived frameworks of law and governance. The benefits of broadening and making more meaningful and effective public participation is advocated by a number of the contributors to this special issue, include Manifold and Jessup, MacDonald, McCormick and Foster, and Morgan and Cush. McAdam explains how the Nansen Initiative on disaster-induced cross-border displacement, by listening to a wide range of views and not imposing a preconceived framework, conceptualised a comprehensive approach to displacement in the context of climate change and disasters. The manner and extent of participation of individuals, groups and communities in environmental decision-making needs to be meaningful. The level of participation is linked to the level of potential influence on the decision or action being considered. The community can also participate in institutions and institution building to promote the mitigation of and adaptation to climate change. These institutions can be public regulatory institutions, but increasingly are private enterprises. Community engagement with these private enterprises may be by shareholder actions, such as bringing shareholder resolutions for climate change transparency to ensure that corporations adequately report on their contribution to climate change and the risks that climate change poses to corporate assets, such as the stranding of fossil fuel reserves. Also for divestment of activities and assets that contribute unacceptably to climate change, such as coal mining, or for greater corporate social responsibility generally. The community may also seek to influence corporate behaviour by divestment campaigns, urging investors to divest from corporations that contribute unacceptably to climate change, such as fossil fuel industries. Richardson assesses the legality of fossil fuel divesting by trust funds and public financial institutions and how fossil fuel divesting might be legally advanced. The community may also build its own enterprises, such as the example given by Morgan and Cush of a community energy enterprise to supply renewable energy to the community. The community may engage in adaptive co-management of projects between the government, project proponents and communities, each party being recognised for their knowledge and capacity to build climate resilience, as Manifold and Jessup argue. The community can provide public oversight of projects, including monitoring the performance and enforcing compliance, a point made by MacDonald, McCormick and Foster. The community thereby promotes good governance. And my third way of encouraging bottom-up regulation is for bottom-up regulation by the environment rather than top-down regulation of the environment. The needs of the environment should drive the law and governance systems for tackling climate change. This ecocentric approach manifests itself in various ways. It involves full implementation of the integration principle, one of the principles of ecologically sustainable development. This principle ensures the effective integration of environmental, including climate change, considerations into social and economic development decisions. Morgan and Cush advocate the need to weave social and ecological values into the heart of exchange and thus to address environmental law goals from the inside out. There needs to be environmental remediation of law and governance systems. An ecocentric approach assists in overcoming the problem of the transcendence of place. The preference of lawmakers for generalisation, abstraction and universalisation of law detaches the law from the place. Environmental law is about the environment and its components as general concepts, but not about any specific place, thing or person in the environment. Morgan and Cush argue that there is a need to invest in place-sensitive, localised conceptions of legal strategies and for reimagining legal interventions and regulatory frameworks along lines crafted by the contours of local place and the vernacular dialects of social space. An ecocentric approach would recognise that ecological systems evolve and adapt and trigger the need for developing adaptive law and governance systems. Responding to climate change demands flexibility and adaptability. Systems that are able to adapt are resilient. MacDonald, McCormick and Foster call for reform of conservation laws to promote resilience to climate change. Bell-James focuses on the carbon storage capacity of coastal systems and suggests ways in which blue carbon can be integrated into the existing legal and policy frameworks. Kelly's identifies the lack of flexibility and adaptability in the market and legal frameworks for the stationary electricity sector as a barrier to dealing with climate change. Not only is the current market framework perpetuating carbon-intensive patterns of electricity generation, but its legal frameworks are designed and embedded in a way that makes change cumbersome and difficult to achieve. There is a need to reform not just the patent architecture of laws regulating climate change and its consequences, but also the underpinning foundations of the laws and the legal systems. For example, principles of the rule of law, legality, and separation of powers are constitutional bedrocks of the legal system, and any action in relation to climate change will be judged against them. There are also the underpinning values that form the normative framework of the legal and governance systems. As I've noted earlier, Morgan and Cush argue that there is a need to weave social and ecological values into the heart of the legal system, not to bolt them on as an afterthought, such as being done with carbon offsets. And finally, reform is usefully directed towards the governance systems. Good governance includes having good laws, but also good implementation and enforcement of these laws. My earlier comments are relevant to these aspects of good governance. But there is also the need to conceive of new forms of governance, including polycentric governance models, commons-based conceptions of governance, or cooperative public-private arrangements that break down the deeply ingrained ideas of the separation of the market as the private domain and climate policy as the public domain. So this special issue of the University of New South Wales Law Journal provides insights and critical analysis of the complexity, the uncertainty, and the value divergence of the problem of climate change, and proposes diverse viewpoints on solutions, particularly relating to legal and governance systems. The articles make a valuable contribution to the ongoing conversation about climate change, and I officially launch it.